I am streaming this on Aaron's, by the way, Twitter page. Hey, everybody. Chuck, Zach, and Jesse here with you. Greg, we're going to excuse him. He's on an airplane coming back from somewhere. But it's great to be with you. We are going to be talking today about a lot of the different things that are going on. Let's just go through the lawsuits, all right? Let's start, though, with the oldest lawsuit that we're kind of part of a much bigger team on, and that's our H-1B fee litigation, which started way back in September of last year. I mean, we had an oral argument like 2 months ago, didn't we, in that case, Jess? Got to be 2 months ago.
Late February.
Yeah.
It's been a minute. Yeah, I think it was the 18th. I'll just say that, like I was just telling you all, like in the DC case, the judge was really pushed to make a decision and didn't make a favorable one. So maybe the judge is taking his time and trying to make sure that he doesn't do something that's reversible on appeal. It's really a complicated issue. It's not as simple as I think, even we've made it out to be. So, yeah, I mean, it's tariff case,
Plus, he's got to overcome the other decision, right? He's got to say why she was wrong. When it's his decision. So that, I mean, it's complicated, but it's still been. Now, who are we to complain? Judge Hannon has been sitting in November on the DACA case.
Yeah.
He's got to issue an order on. He doesn't even have to write an opinion, and he's got to issue an order, and he's just sitting on that for 6 months. So, and we know, of course, that it could take 2 years, like our appeal in the last DB case did. So that's kind of where it is. Let's jump to the F1 visa revocation case. This is the one that we filed, really started last year, right before the government shut down. And then the government shut down, and then it was the holidays, and the government kept getting extensions of time to answer. And then they finally filed a motion to dismiss, which we responded to. I think their reply is due Friday, Jess, or did they already? I don't think they filed a reply in that.
No, they filed a response to our submission.
I think their reply is due Friday. I think.
If it's not Friday, it's
Monday.
Within the next 4 or 5 days. Yeah.
So what that means on the visa revocation case, for those of you these are the people whose severance was revoked, severance was restored, but their visa was revoked at the same time for the same reason that severance was revoked. And we're really cutting new ground here. We're plowing new ground here on the issue of restoring visas. Now, there has been one TRO that came up in an individual case, some Boston, maybe Washington somewhere, that we gave to copy to the judge, where they forced the visa to be reissued or restored. A problem for some of our plaintiffs, Jess, is some of them visas have actually expired. Even if they hadn't been revoked, they would have expired at this point. But they're all terrified of going back home to get a new visa with this Damocles sword hanging over their head. So I feel pretty confident about the motion to dismiss, though. So
yeah, they can't go home and get a new visa. I mean, everybody, yeah. I mean, it's
that I know that's gone back, except for one, has been denied a new visa. So
I think the game would have to be. I mean, you can't go back and try for an F. You'd have to go back and maybe try for like an H or an O, something like that. And I think you may have a chance. But if they can deny you 214B, even with an F, I think, or a J1, I think you're in trouble.
All right.
I've had a few people with H1Bs for that. Yeah.
So there we are on that one. I know a lot of people are super interested in the DV 2026 lottery case. Jess, you want to fill them in where we are on that?
Yeah, I mean, we've kind of merged our timeline with the other case that is pending. Our motion for summary judgment is due Friday. We already have the record. Nothing that is groundbreaking. And
tell us about the record, though. What is this record? What is this for those that are clients who don't know what this is? What is it supposed to be?
So the record is supposed to take. It's actually not for us. It's not for defendants. It's for the judge to decide. He needs to look at everything that went into the decision in the case. And it's actually a rule in the Administrative Procedure Act that the government has to provide and present the judge or the court the record. And the court is supposed to decide the case based on that record. The record is supposed to be every relevant piece of information that went into the decision. So we have a series of tweets, some posts, a couple cables. Essentially, though, you know,
but we don't have anything behind the cables. Like who?
But there wasn't. There was. I don't know that it exists. I mean, it was kind of this incident that occurred by this Portuguese individual who found
out from this, right? We found out who it was, right?
Right. Found out who it was. And then I think it was Secretary Noem who started the, you know, hey, we're going to just do this. I mean, it's so pretextual. I don't know what their defense is going to be. You know, so it's much like the 39 country pause, right? Let's find an excuse. Let's find something bad in the news. You know, I tell all my friends from Europe, I'm like, we're like one Brit Simon rampage away from all British citizens having their visas revoked. And we know, right? I mean, we have the World Cup coming out. I'm like, I tell all, you know, in Massachusetts is a large Brazilian community. I'm like, oh my God, it's going to take one drunk guy and all Brazilian. I mean, they can't get immigrant visas anymore, but I mean, forget it. I mean, it's really, I mean, it would be funny if it wasn't so tragic because that's their decision making.
It's juvenile. It's juvenile decision making. We had a quote that a little sentence I put in. It was taken out, which is probably better. Did you leave that little insinuation about the pre-crime thing in there, Jess, or did you take that out?
I had to take it out. I'm sorry.
It's fine. But my argument was that this is what they're saying is we can't restore the program till we know that anybody we admit will never, ever commit a crime.
Yeah.
Or never, ever use welfare. So it's like the Department of Pre-Crime, right? That's from the Tom Selleck Minority Report movie. I thought that was clever, but I get it. You know,
it is. I mean, it's so frustrating because, you know, it's very similar to all the pause litigation, the 75 country, everything we're talking about. It's so pretextual.
Except DV, what's special about DV is that there's a deadline.
Yeah.
You know, they can't argue, well, you know, we'll get around to it eventually. They'll eventually get visas. That is literally not the case here.
There's a deadline, and then there's also numbers and visa bulletins that are very, very important each month, and there's only a couple left. And, you know, I know Simon's been all over it about, you know, how they're playing a little bit with the numbers, but, you know, it wasn't a perfect system before, but the pencil down system and ignore and turn my back to it should be outright rejected by the judge. And I think our PI motion was great.
Really?
We kicked out, everyone kicked their ass on it. And now we're working under the gun. I mean, this will be our second round of full briefing now with the record in less than a month. So
it's due Friday, but we're not waiting till Friday, are we?
I think, well, there's always kind of the file early. I don't want to give the government an extra day, so I probably will file it Friday.
Because otherwise they have an extra 2 days because their deadline doesn't change.
I mean, there's no mystery behind it. They already have our PI materials, but
right.
I mean, you know, I think though that the idea that, and I know Simon or someone tweeted like, oh, someone got a DV, which is so weird to me. I don't know if that's true or not. I think there was maybe I dreamt this. I thought, I'm not a big Twitter guy, but I thought someone had posted a picture that someone had got in a DV. But I think the notion that they're gonna, you know, lay down and you know, it's kind of what we see with habeas and CVIS and everything else. Like they are forcing judges to make decisions, and if they lose, they don't care. Like that's.
Well, they really don't care. They really don't care.
I mean,
and, you know, they might immediately try to get us, you know, we're going to win. I'm really confident we're going to win this. I think the law is clear on this. You can't just not do your job. You can't just not issue visas. But they'll probably go right to an appeal, try to get a stay. And so we're going to be dealing with that right away. But keep in mind, when last time we won this case, we won it on September 9th. and they issued 9,000 visas in 3 weeks. What we put in the brief, based on information given to us by Simon, was that they probably issued about 7,000 visas, probably in the 3 months before they, which would be about pretty typical. Could they issue 48,000 visas in 3 months? Probably not. Probably not. Could they issue 30,000 visas in 3 months? 100% they could do that. So kind of where we are on this. So that's the update, and we will keep you apprised. We will, once we file the motion, we will post it on the IMMPact website with there's some record sites to some names, and we'll redact those names in the posting. All right. Next is the 39 country ban cases. Zach, I know this is Zach's wheelhouse right here.
Think about DV. I know DV exists, and I know these guys do stuff about it, but that's about as far as my knowledge there goes. Yeah, so we got 2 cases now moving forward with the 39 ban case. So I'll start with Georgia. We've got the one that we've got the PI fully briefed. We had the oral argument mid-March. Judge Grimberg there is really on top of it, really knowledgeable about what's going on, and really just seemed to want to have all of the facts before he made his decision. So wanted to see what came out on April 1st. And as we all know, nothing did. We got this post on the USCIS website that basically reiterated what they'd already said on March 3rd. And then we actually provided more of an update, I'd say, than the government did by getting a leaked email from a reporter saying, hey, here's what's happening behind the scenes, Judge. You know, you're not getting the full picture from the government. So I feel pretty good about that. The government then did have to file their motion to dismiss. I know folks were concerned, like they were doing it as a delay tactic or something. It's just a required step in the process. Like they have to respond to the complaint and either answer it or they file a motion to dismiss. Filed a motion to dismiss. So we responded yesterday, Monday, a couple days ago.
Good response. It's a joke of a motion to dismiss.
It is an absurd motion. They had an argument about venue that no court ever has agreed with. I mean, just some truly just absurd arguments in there. But and we responded to it. I think it looked good. Sent it out. I think all the plaintiffs should have it now. And hopefully, if the judge had any questions about really any part of the case, that gives him just a little bit more to go off of, and maybe that's what's going to kind of spur this decision. I said April 10th was when I was expecting it. Here we are, April 15th, and no decision yet. So I'm like checking my inbox every 5 seconds to see if we have a decision coming out. Expecting it like really any day now is kind of the best I can give folks. Then separately on the 2nd of April, we filed another case in District of Colorado, filed on the 2nd because we wanted to make sure that nothing happened on April 1st that just totally changed the game. Nothing did. Filed that on the 2nd. We've been going in circles with the clerk of the court here. It's first court I've ever had to deal with that makes you list every single plaintiff on every single thing that you do, and they don't really seem to know how they want us to handle it either. So going in circles. We got it figured out though. We're gonna have the PI motion filed tomorrow and serve that with everything. So it should be a pretty quick movement.
Who are we assigned to? What judge are we?
Right now we just have a magistrate, but we're going to decline the magistrate, so we'll be reassigned. I'm going to make a guess that it's going to be Blackburn, Judge Blackburn. He's a senior status judge who's his whole thing is Administrative Procedure Act cases. He loves them, hates doing trials. And so anytime you file an APA case here, he is your judge. Love the guy. But maybe not because he's senior status and they don't want to take a huge workload. But if I had to bet, that's who I'd be choosing.
What's interesting with these cases is they are scheduling people for the oath ceremonies again.
Yeah, I've heard a couple of reports of that.
Clear as day. I mean, they just did it for one of mine in DC.
But you file litigation on it? Was it pending?
There's been a couple even without the people who had canceled oath ceremonies. It's not 100%, but I mean, it's definitely a noticeable change. I don't know if they just, made those go outside the queue. I mean, we've had other cases too. I've had 3 I-130s approved. So, I mean, those are all in litigation.
People are going to know what countries.
Yeah, I mean, I think 2 were Iranian, 1 was Venezuelan.
You had an Iranian approved. I mean, that's
my Nats guy is an Iranian.
yeah, they were going to lose that Nats case, so they had to do that. There's no way.
Yeah. Well, it's crazy in DC. That court will just swear him in.
Really?
Yeah. It's DC court will just because they hold those ceremonies before the federal judges there. Yeah.
Well, they do in Atlanta too, but only once a year.
DC, it's like once a month or something.
No, Atlanta, nobody wanted. They're all lazy. I guess they want to do it. So that's the 2. Now then, we are onboarding right now for a third 39 country ban case, and that's onboarding on the IMMPact website.
Yeah.
So if you're interested in that, and you think
the other thing with the 39 country pause, if they don't stop it, it's starting to bleed heavily into H-1B. Big time. You see it all over the listservs and everything else. Like people are really cap and the staff.
Well, actually, the worst part is the OPTs.
Oh, absolutely. No, I mean, there's
OPTs are a nightmare. I mean, this is what you have to sue. I mean, some students are all graduates. Graduation week starts now in some schools, right?
Yeah.
So what should I do? Well, you should apply for OPT. Well, they're going to send an RFE or they're going to send a NOID. It doesn't matter. It keeps you in status.
Yeah.
While it's pending, you're in status for 240 days. So file it and then join the 39 ban country lawsuit so we can put you in. I mean, this is not a mandamus. We're not filing mandamus demanding action immediately. We're demanding that they obey the law and take cases in order. So got to sign up for that. That's next. So next one, Zach. Oh, any more on 39 country bans, Zach?
Or move on though. So we don't have the deadline put on the website. Folks who are in charge of the website are in DC this week, but it's April 30th is what we said, and we're gonna have a filing of that on May 4th. So just know, we've got a couple of weeks there. There's some rumors out there. We want to make sure that we get ahead of them. So April 30th, that's our deadline for signing up for our next round.
All right. Next is the 75 country pause ban litigation. Zach, you really had that one too that you're leading on. Tell us.
Any pause, throw my way, I guess. So for this one, there's a couple of cases that are moving that are doing a really good job there, and we've gotten the records from them already, which has put us in a really good spot. So we have a PI that we've put together and is ready to go, but we've kind of changed up our tactics. How we're going to do now is just move directly for summary judgment, get this final durable relief immediately for plaintiffs and jump right into that rather than having to brief summary judge or a preliminary injunction first, wait for the judge on that, and then go into the summary judgment afterwards.
There's a strategy behind that too, Zach. I mean, to get a preliminary injunction, what are the requirements?
I mean, it's just a heightened standard there. It's not a typical thing, I guess.
Yeah, it's the irreparable harm that's the biggest hook for us. If you're subject to the 75, I mean, you could probably meet that standard, but irreparable harm is not just, hey, I'm separated from mom, or hey, I have a good job offer. I think there's a case that was filed first by some organizations in New York, and I know there's been PIs filed, but keep in mind, what's a PI get you? Get you a 28-day order and a ham sandwich. Summary judgment gets you the whole cannoli, and that's what we want, and we want it in the shortest amount of time possible. So I don't think that this actually delays anything. Actually, it accelerates a final judgment, which is what our clients need. And we'll probably have some other judgments issued before that. So, I think it's, if anyone wants to blame somebody, I guess they can blame me.
There's no blaming here. This is strategy litigation.
But I mean, I just, I think if you want to do a PI, that's great. Go for it. I don't know. I think the irreparable harm element is a tough one in the 75 country. I mean, the policy is ridiculous. Don't get me wrong. It does nothing about the lawfulness of the policy.
No, the policy's a joke.
But in terms of the imminence of harm, you really have to convince a judge that you need a decision today and that you can't wait.
And that's because you're taking the case out of his order. Other stuff aside.
Yeah.
And one of the nice things is because we've already got summary judgment moving forward in one of the other cases, I mean, we're in the same district. The judges are going to be, I mean, if we don't have the same judge, the judges are talking. So, things are going to move faster on that side of things as well.
And here's the thing, everyone, let's just to bring it back to DV for a sec. When we did our PI and we did amend our complaint, and so we have the 75 country thing tucked into our DV complaint too, and we're already filing that summary judgment. So we're getting really 2 bites at the apple here, and we're on a very quick timeline. So it's not as if we're going to be waiting for a judgment on whether the 75 country pause is legitimate or not. I think we're going to get that either in the DV case or in our 75 country only case, doing it the right way.
I think with the tight timeline we have ordered by the judge in the DV case, we're going to have that judge is going to have oral argument. He's going to want to, no doubt about it. But I think he'll set that very quickly after the government's final response in mid-May-ish May.
I can wear shorts, right?
At least until you walk in the courtroom.
Oh, okay.
So you walk in, and then you'll have to drop the pant legs down until we get done.
Yeah.
Hey, the last one is the onboarding, which I think ends today on the DV 2026 AOS litigation. Now, John is not with us. Got the intakes. I don't know what the intakes are there. But somebody asked today in Letter Live, are we filing it tomorrow? No, it takes first we got to find out where we're going to file it, depending on where the plaintiffs are. We don't know where you are until we've got the final numbers. And then the litigation itself has to be written for that district court that we're filing. We'll be filing that next week, though. And again, I don't know the numbers. I don't know anything signed up. John has that information, and it's just coincidentally, there's a massive immigration lawyers conference in Washington D.C. starting today, and that's where Greg is, where John is, it's where all of our Aaron is. Everybody's there. All the important people go to that. Those of us who used to be somebody, we don't have to go there anymore. So we get to stay at home.
The one thing with the AOS, the USCIS used to be so great. With getting these cases done. I mean, the most difficult issue, I guess, for people who are in the United States with DV selection notices is the bulletin. Yep. They got to have that visa available so they can file. I mean, I don't believe. I think they would have standing to file before they
it's harder.
Were eligible, but I don't know that I'd recommend it. I don't know. I can see it both ways, but I don't know where the bulletin's going to go. No one does, Now,
remember this for our plaintiffs. We're not your lawyers on your green card application. Yeah. You have your own lawyer for that. You have to have that. Once we get this to the judge, your lawyer needs to be calling up the local office every day, every week, every day to get you adjudicated by September 30th. Or I don't think they're going to run out this year. I'm not worried about them running out of visas this year. But they've got to be on top of that. We're not doing that part of your case.
I mean,
we're opening the door.
It's like everything else. It's like, oh, I don't, you have to be ready to do your biometrics. You're gonna have to, make time available if they call you in, for sure.
And you're going to be interviewed. 100%, you're going to be interviewed.
Oh, 100%. No question.
So, we've got some in the comment section here. There's some questions. Stephen Brown is looking at us. Thank you, Stephen. You are very kind, by the way.
Look at that suit.
That guy, Stephen's the man. Britt Simon is watching us today. Simon is kind of our backdoor expert. I'm pretty sure, Jesse, there's nobody in America or in the world that knows more about the diversity lottery than Simon.
There's no question.
I think he knows more than people at the state, actually, that know this. So thanks
he may be my favorite non-lawyer. Besides Heather, but Britt,
I get
Simon's up there.
He's up there. Great picture, by the way. DV case, will the lack of movement in the visa bulletin and DV 3 months basically be included to argue bad faith by the government? I would defer to Simon on this. I mean, I think they're playing with the numbers here, Jess, a little bit, but they obviously they're now lowering. I think they're lowering the numbers they're going to use. Right? They're no longer going to get 55,000 because they can't possibly use 55,000.
Yeah, I think bulletin litigation is a kind of a no-go zone. I don't think you can really do much with that. It's like challenging retrogression. It's been tried. It doesn't work well. I think the best thing that what could happen is we'd get a favorable order with an immediate direction to start doing cases, and that should impact the bulletin for that July and August bulletin, hopefully. Yeah, I mean it's not a surprise. I'm actually, you know, the numbers are what they are because they've done nothing for 4 months.
Right, and I don't think the NBC is doing anything either. My guess is they're doing nothing.
And they're supposed to be doing everything up until final.
Right, you know? Exactly. Even if they're not going to adjudicate it. Well, there's definitely some really terrible immigration judges left to these days. Zach, I know you go to immigration court occasionally. I know Jesse doesn't go anywhere near the place. Smart man.
No.
But by the way, I do have a FOIA pending on the order from January to immigration judges to start denying bond. And that is now subject to discovery in a habeas case in the Middle District of Georgia that I'm involved in. So there is, the judge, in fact, ordered the deposition of, the government presented like 10 names, including Margolin, right, the head guy. And they decided to have Circe Owen deposed.
No way.
Yes, way. Who knows nothing about this because she wasn't the chief immigration judge when this happened. It's like putting forward, hey, this person knows nothing, but they're a sacrificial lamb, so have them go testify.
Yeah.
I think they forgot where we can do interrogatories in a habeas. They must have forgot that part. So good point. Suppression of visible, obviously a plan to suppress plaintiffs. They're wasting embassy. Yeah, clearly bad. A lot of the comments are from Britt here. Red Eagle has filed a PI motion. Just wondering what the strategy. We just talked about the PI. We're going right to summary judgment. We want the final order. Final order. Yeah, they made it, like I said, E-grades. There's no way they can issue the rest of these visas. Riemann, the third one in D.C. that was filed February 4th. There was a third one. I don't know what that refers to.
DV case?
Maybe it's the DV case?
Yeah.
The government did provide a list to the judge of cases, but I think several of them were individual cases.
And they weren't all DV either.
No, they weren't. It was kind of a weird list. When to expect a decision on the 100,000? Hopefully.
Could be in my inbox right now. Yeah.
I mean, hopefully soon. I mean, obviously the damage is done at this point for this year. What are our chances of pressing a stay of execution? I think he's referring to the DV.
Pretty good.
Case. Well, they're going to do it. They're going to request a stay.
Yeah.
But we'll fight that tooth and nail. And I do not see a court of appeals staying that case. I just don't see them doing it.
It's going to depend on the panel. You know, if you get
DC judges, I mean, there's a lot of Trump judges on the DC circuit these days.
There are. I know.
And every one of them thinks they should be on the Supreme Court.
Well, I mean, they better start, you know. I mean, they're not going to get appointed. They're not going to get appointed by Trump. So they're probably going to.
How are they going to get ahead of Mike Lee? That's what I want to know.
Jesus. Right? Heaven help us. But
what are the chances of the government appealing the ruling requesting a stay? They're going to do that. You don't have to ask a question once, by the way. What happens if they ask for a stay in the EV case? What do you think the judge is going to predict to happen? Curtis optimism early June. I think the judge will have an oral argument in late May and have a decision by early June. The judge understands, because we make a point about this, and I'm sure Curtis does the same thing, that there's limited time frame. Tick-tock, baby. Tick-tock. Okay, there's a case called Chakumba versus Department of State filed February 4th.
It's awesome.
Great. I don't know who's doing it or what it's about or anything. Which one is more effective, mass action or class action? This is a great question, Azadeh. Jess, is it easy to do a class action in 2026?
I mean, no. Not at all. I mean, class actions now are subject to kind of regional limitations, and it's tough to get a nationwide class. I think the better question is it better for me to join a group or doing my case myself? And I think if you're a Nats applicant, that is a really good question. And it probably depends on whether you've been interviewed or not, because there's a specific statute if you've been interviewed where you can file your own case. But I think a class action and a mass action, I mean, when you take on responsibilities to represent an entire class, you have to understand that you are signing up for something that's bigger than yourself, and you're going to have obligations going forward. And your attorneys are doing the same thing, which is why class action is very hard. We've done it multiple times, but it's an enormous undertaking.
And it's honestly, it's a lot harder than it was 3 or 4 years ago.
Yeah.
There's a certain Supreme Court decision that made these very difficult to get certified.
I think the other thing is it's a lot slower when we're like the H-1B fee litigation, for example. That's a class action, and that's I mean, that's moving slow since we filed October 3rd, I think.
Yeah. Yeah, it's not like clicking a box. It's a whole separate set of motions and evidence requirements. So
it's a lot more work. And when you get to the final decision, you get the same exact result if you're working on the EFA. We're stopping a policy, and you get the same exact. But I think you may even get a better result, because a lot of class actions are going to be regionally limited or state limited, and whereas a striking down a policy is gone for everybody.
Yeah.
So the mass action works in many ways is the same way. Now, what I'm waiting for them is to start attacking venue, right? To start, adopting changes or different interpretations of venue and joinder, which is the basis of a mass action.
Yeah.
More discovery evidence you're hearing. So maybe that's true.
That 39 country ban motion to dismiss had a venue challenge, and I think it was pretty poor. It's possible in a lot of cases, but I don't think it's also a magic wand for the government.
75 country ban. We've already talked about that in detail. What we're going is for the summary judgment in that case. The deadline for the 39 country, I think, Zach, you said was April 30.
That's a serious profile pick right there.
Yeah. Is the $100,000 rule only good till September 2026? If you think they will renew that rule, you're dreaming. I do love the profile picture. Very nice.
They have to do it though. It's not self renew. It's not like a subscription.
We don't have 2 diversity lottery cases. Chicumba's a different case.
No. Chicumba's the visa issuance one, and this is kind of the same playbook as the 75 country
lottery case.
It is one of ours challenging the visa issuance part of the 39 country.
Yeah, but it's not the diversity.
Playbook, yeah.
Phil Velez, one of my favorite folks on Twitter, and he must have demonstrated bad faith beyond bad bond hearings in federal court. Philip, that's actually going on right now, just so you know, in the Middle District of Georgia, in front of Judge Lamb, who has authorized depositions and discovery of the bond hearings, because in the Middle District of Georgia, we had 3 judges at Stewart, one of whom was giving bonds, and the other 2 were not giving any to anybody. And we documented that by sending observers in. And one judge is basically, she wrote that didn't look at the papers, never read a thing, and she said flight risk and just denied it, and didn't issue a decision. But interesting enough, once the judge ordered discovery, guess who's now giving some bonds? Yeah.
The judge?
Yeah.
For us, in Aurora here, it's like, rather than just denying on flight risk, they've kind of just made it so high that nobody can afford it. We got some data from the American Immigration Council a few years ago, average of $5,000 for a bond. Right now, the average is $25,000.
See, Stewart's been about $12,000 for like 10 years, and it's kind of been the norm for $12,000. But recently, we've seen some $25,000, $30,000 bonds, which obviously is a joke. I mean, this is done to make sure you can't get out of custody. So anyway, that's all the comments and questions for today. We're grateful for everybody participating. We'll come back next Wednesday with some more updates. Hopefully, we'll have some good news to report by next Wednesday. And for all my DACA friends that I'm sure are watching, maybe Judge Hannum will get off the can and issue a decision as well. Thank you guys for attending today. Have a great day.
Bye-bye.
Okay.